They're using our product. Help, I need you to hit them with a cease and desist letter today. As a patent attorney for funded startups and growth stage companies, I hear this constantly, both from my clients and just people calling me asking for help. It's an emotional reaction for sure. You want to protect your hard work, but as your strategic partner, my job as a patent attorney is to look at the math with you. According to the 2025 to 2026 industry data from the AIPLA Economic Survey, the average cost today to litigate a patent, filing a patent lawsuit in the US, is now approximately $2.8 million. So before you send that letter, you need to know if you're buying a win or an expensive disaster. Here's the danger most founders don't see. If you send a cease and desist letter too soon, you might accidentally start a war you aren't ready to pay for. By threatening litigation, you may give the other party the right to file a declaratory judgment action against you. They basically beat you to the courthouse, asking a judge to rule that your patent is invalid or that they aren't infringing it. Suddenly, you find yourself in the middle of a multi-million-dollar lawsuit that you didn't budget for. And if you aren't ready to move forward, your only way out is often just going to be to abandon the effort with prejudice. That means you walk away and you can never bring that claim against them again. You've effectively handed them a free pass to use your technology forever. I remember a CEO who came to me, it was probably about 15 years ago. He had that same fire and brimstone energy. But instead of rushing to a C&D, a cease and desist letter, we paused. We asked, do the claims actually infringe? You'd be surprised how often someone thinks their patent covers everything, when in reality it doesn't. 2, can they easily design around your patent? If we had sent that letter, they would have just tweaked their design to bypass the patent. Instead, in that case, I realized that they had pending patent applications in the chain. We stayed quiet and drafted new claims specifically designed to cover their new product. We built a trap, essentially, while they were still in the dark. Then, the CEO approached their president with a licensing deal. It was a win-win. Here's something important to keep in mind. The true cost of litigation is dictated by the amount at risk. That means if you're chasing damages under $1 million, you're still going to spend $250,000 to $400,000 easily just to get through discovery. And if you go to trial, you're looking at maybe $600,000 to $900,000. No, litigation's not cheap. If the stakes are, say, between $1 million and $10 million, the trial alone can cost $2.5 million. And get this, most law firms won't take these cases on contingency. That means you're fronting that cash. And if it's a fly-by-night competitor you're going after, they'll disappear before you collect a dime. If it's a big corporation, they will intentionally outlast and outspend you. So the better approach? Strategic portfolio architecture. Strong enforcement starts years before the infringement happens. I draft patents for my clients with licensing leverage in mind. I want to create a situation where, when my client does approach a competitor, they see a licensing deal as a bargain compared to a $2.8 million court battle. A lawsuit is a tool, not a default. If you're facing an infringement situation, clarify your objective before you make contact. Don't risk a declaratory judgment action that could kill your patent rights for good and put you out of business. If you want to evaluate your portfolio's actual leverage, book a strategy consultation at the link below. Let's make sure your IP is a business asset and not a liability.